The United States Supreme Court was filled to capacity. An electric charge hummed through the grand marble chamber as every eye settled on the tall, commanding figure at the lectern. Denzel Washington, dressed in a finely tailored navy blue suit, stood poised and calm, his presence so composed it made the oxygen in the room feel thinner. The murmurs among the spectators had died down, replaced by a reverent hush as the moment everyone had been waiting for arrived. Cameras weren't allowed inside, but the room was packed with legal scholars, journalists, and law clerks, all eager to witness the unprecedented event. A Hollywood legend, arguing before the highest court in the nation, not as a plaintiff, not as a character in a courtroom drama, but as an amicus curiae in a live, high-stakes constitutional hearing. From the elevated bench, the justices looked. Sire. Chief Justice John Roberts adjusted his glasses. Justice Clarence Thomas, characteristically quiet, observed with narrowed eyes. Justice Brett Kavanaugh glanced down at the brief before him. And at the center, Justice Amy Coney Barrett watched with the sharp gaze of someone prepared to pounce. Washington adjusted the microphone, cleared his throat, and began, his voice steady and clear. "May it please the court," he said, his deep, deliberate tone commanding attention without force. This case, Williams v. United States, is not simply about regulatory overreach. It is a test of how far our government may stretch its authority before it violates the very freedoms it was created to protect. He had barely finished his first sentence when Justice Barrett cut in. "Mr. Washington," she said sharply, her voice slicing through the chamber, "while your celebrity status might be impressive in Hollywood, it holds no weight here." A flicker of tension passed through the crowd like a gust of wind. She continued, "Are you certain you comprehend the constitutional complexity involved in this matter? Your brief, though stylistically polished, seems to lack the doctrinal depth we expect in this forum." The room gasped. The silence that followed felt amplified, unbearable. Reporters scribbled furiously. A law clerk's pen fell to the floor with an audible click. Washington didn't flinch. He didn't fumble through papers. He didn't stammer. He simply tilted his head slightly, his expression unreadable but calm. Then he looked Justice Barrett squarely in the eye. "Justice Barrett," he replied, his voice just as composed as before, "I assure you I did not come here relying on fame to speak for me. I came with constitutional history, judicial precedent, and over 3 years of intensive research to back every claim in that brief." Barrett's eyebrows lifted just slightly, a crack in the armor. "Then by all means proceed," she said, coolly, settling back in her chair. But in that moment something unspoken passed between them, an acknowledgement, however faint, that the man standing before her might not be the dilettante she assumed. And as Denzel Washington turned another page in his notes, the Supreme Court braced itself for a confrontation none of them had quite expected. The case before the court, Williams v. United States, had already been dubbed by commentators as the most consequential First Amendment challenge of the decade. At its heart was a constitutional question with massive implications. Could the federal government indirectly compel content moderation on private digital platforms by using regulatory pressure, or would such actions violate free speech protections under the First Amendment? For months, the legal community had debated the stakes. The petitioner, Malcolm Williams, was a digital journalist whose independent media platform had been repeatedly flagged and demoted in search rankings after the Department of Information Integrity, created by executive order, issued guidance to major platforms suggesting certain disruptive narratives be de-emphasized. The result? Suppressed traffic, lost ad revenue, and accusations that the government was skirting constitutional boundaries by outsourcing censorship through regulatory suggestion instead of law. The government argued it hadn't forced anything. Williams argued otherwise, and he had the email chains and internal documents to prove it. But no one expected Denzel Washington to enter the legal arena. That changed when, weeks before oral arguments, an amicus curiae brief surfaced. It bore a name that made even seasoned lawyers blink. Washington, Denzel, J.D., Howard University School of Law. In the weeks that followed, Legal blogs erupted with speculation. Is this real? Did he hire ghostwriters? Is this a stunt? But anyone who read the 43-page brief knew it wasn't just real. It was brilliant. The analysis was originalist in scope, weaving historical context, judicial precedent, and modern implications with startling fluency. Even so, skepticism persisted. You mean the actor from Training Day is lecturing us on constitutional doctrine? One senior partner at a DC firm scoffed on a legal podcast. Come on. But Denzel hadn't just studied law, he had lived it. While filming films and producing plays, he quietly pursued a law degree at Howard, studying late at night, submitting papers under initials to avoid attention, and ultimately graduating with highest honors. His professors described him as meticulous, relentlessly curious, and completely unpretentious. Now, as the courtroom absorbed the weight of Williams, the stakes couldn't have been clearer. This wasn't about one man's website. It was about the boundary between speech and control, private freedom and public influence, and the man standing before the court, famous, doubted, yet frighteningly prepared, was ready to defend that boundary with everything he had. Justice Barrett leaned forward, her eyes sharp as a scalpel. Mr. Washington, she said, folding her hands on the bench, you're aware that for a government regulation to survive First Amendment scrutiny, it must pass the strict scrutiny test, correct? Denzel didn't hesitate. Yes, Justice Barrett. The regulation must serve a compelling government interest and be narrowly tailored to achieve that interest by the least restrictive means. Barrett nodded curtly. Then how do you reconcile that with your claim that the government's guidance to digital platforms, which you describe as coercive, even rises to the level of a regulation? There was no mandate, no statute, merely suggestion. Denzel stepped forward slightly, his voice steady but forceful. Respectfully, Justice Barrett, suggestion from the federal government carries weight, particularly when backed by implicit threats of regulatory consequences. In Bantam Books v. Sullivan, this court held that informal censorship, even without statutory force, may still violate the First Amendment when coercive pressure is applied. Justice Kagan raised an eyebrow. Impressed, Denzel continued unflinching. And in Brandenburg v. Ohio, the court established that even unpopular or controversial speech cannot be suppressed unless it incites imminent lawless action. Here, no such threshold was met. And in Reno v. ACLU, the court struck down the Communications Decency Act for being overly broad in regulating online content, setting a precedent that caution must be exercised when regulating the digital space. There was a brief pause. A few justices leaned back, processing the fluency with which Washington cited decades of complex doctrine without notes. Chief Justice Roberts raised his eyes from his papers. Justice Barrett, visibly narrowing her gaze, shifted tactics. Yet, Mr. Washington, she said, your argument appears to contradict principles this court laid out in Holder v. Humanitarian Law Project, where it upheld restrictions on providing material support to foreign terrorist organizations even when that support was purportedly expressive conduct. The court accepted that the government's interest there was compelling enough to restrict speech. A subtle smirk played at the corners of a few lips around the bench. It was a gotcha moment, or so it seemed. Denzel didn't miss a beat. Justice Barrett, he said with quiet authority, in Holder, the government's compelling interest was national security. The speech in question involved direct coordination with designated terrorist organizations. This case, by contrast, involves a domestic journalist whose content challenged prevailing narratives but did not endanger national security. Furthermore, he paused, flipping a single page of his notes. As Chief Justice Roberts himself noted in his dissent, preventing unpopular speech is not a compelling interest in a free society, no matter how inconvenient that speech may be to the state. Justice? Barrett's lips parted just slightly. It wasn't often her own colleagues' words were quoted back to her so precisely. From his seat, Justice Thomas gave a slight nod, almost imperceptible. Justice Alito leaned toward his microphone, but then pulled back. Whatever he was going to say, he chose to save it. The air in the chamber had shifted. It was undeniable. Barrett, to her credit, didn't double down. Instead, she studied Washington with the look of someone reconsidering a first impression. "The court appreciates the clarification, Mr. Washington," she said finally. "Of course," Denzel replied with a respectful dip of the head. Around them, the tension didn't so much dissipate as evolve. What began as skepticism was quietly giving way to intrigue. No one had expected Denzel Washington to walk into the Supreme Court and hold his own, let alone teach doctrine back to its creators. But that's exactly what was happening, and the 9 justices, to varying degrees, were beginning to take notice. Denzel paused, sensing the courtroom's shifting current, curiosity replacing condescension. Then he reached into the leather folio beside him and withdrew a slim bundle, bound carefully in archival plastic. "Your Honors," he began, his voice composed but charged with quiet intensity. "In preparing for this argument, I conducted extensive research into the original understanding of speech protections at the time of the Constitution's framing. Among the materials I reviewed were private correspondences housed at the Madison Collection, Library of Congress." He lifted the top document gently. "This is a letter, previously unpublished in any Supreme Court case, written by James Madison to Edmund Randolph in April of 1791. It details his concerns about indirect forms of government influence over speech, specifically, the fear that the federal government might one day exert pressure through unofficial channels to achieve what it could not lawfully mandate." He handed the copy to the court clerk, who walked it forward. The justices leaned in as the material was distributed. Barrett unfolded the document, her eyes narrowing as they traced Madison's neat cursive, annotated in Washington's own hand. "In that letter," Denzel continued, "Madison warns, and I quote, 'The danger is not only in laws plainly passed to muzzle dissent, but in soft manipulations and governmental suggestions that carry the weight of command through implication. The very whisper of executive disapproval may chill expression, and that chill may prove fatal to the liberty we so recently secured.'" A collective stillness filled the room. The weight of Madison's words, echoed across 2 centuries, hung in the air. Justice Thomas shifted in his chair and, to the surprise of many, leaned toward his microphone. "Mr. Washington," he said, his voice low and deliberate, "you reference sources overlooked even by prominent constitutional scholars. Who assisted you in compiling this material?" Denzel met the justice's gaze. "No one, Justice Thomas," he said. "I visited the archives myself. I spent months combing through handwritten drafts and letters between filming commitments, between scenes, and sometimes between takes. I worked with the archivists only for access, not interpretation. The notes, the citations, the legal framework, it's mine." Thomas was silent for a long moment, then offered a rare nod of acknowledgement. Justice Kagan leaned over her stack of documents, whispering something to Justice Sotomayor, who responded with an arched brow and a slow smile. Even Barrett appeared momentarily caught off guard. She turned the page, scanning Denzel's annotated transcription, lips pressed into a thoughtful line. "Mr. Washington," she said finally, quieter than before, "this material is not part of any previous amicus briefing before this court." "No, Justice," he said, "but I believed the founders' own voices had a place in this courtroom, especially when the subject is the restraint of speech through unofficial power." The atmosphere shifted once more, not with tension, but with something bordering on reverence. Denzel Washington hadn't just earned the court's attention, he had earned their respect. Justice Barrett sat motionless for a moment, her gaze fixed on the final page of Madison's letter. The courtroom was silent again, this time not from tension, but awe. Slowly, she lowered the document and looked directly at Denzel. "Mr. Washington," she said, her voice now devoid of the earlier edge, "your understanding of original constitutional intent is remarkably thorough, more so than this court has heard in recent memory." A ripple passed through the room. Chief Justice Roberts, seated to her left, adjusted his glasses and offered a small but unmistakable nod. His earlier skepticism had evaporated. There was something in his expression now, regret, maybe, or admiration. Denzel nodded graciously, then stepped forward. "Thank you, Justice Barrett," he said. "With the court's permission, I'd like to propose a framework, one that honors constitutional protections while acknowledging the realities of modern governance." He paused, scanning the bench. No one interrupted. "First," he began, raising one finger, "any government communication with a private entity concerning speech or content moderation must be subject to disclosure and judicial review. Secret influence is inherently coercive. Second," he continued, "any such communication must serve a compelling government interest, not convenience, not preference, and it must demonstrate that the government's concern is grounded in public safety or imminent harm. Third," he concluded, "the government must prove with clear and convincing evidence that its actions are the least restrictive means available and do not result in viewpoint discrimination. Anything less violates the very heart of the First Amendment." Justice Kavanaugh leaned in, scribbling notes. Justice Sotomayor watched Denzel closely, lips pressed together in quiet thought. Even Justice Alito, often rigid in expression, had softened. Roberts cleared his throat. "That test," he said slowly, "doesn't merely restate strict scrutiny. It articulates a functional, transparent approach for evaluating government influence in the digital age." Before Denzel could reply, the Solicitor General stood. "Your Honors, if I may," but his voice cracked slightly. He gathered his papers and tried again. We contend that the government's interactions with private platforms were entirely voluntary and voluntary," Barrett cut. "Coercing yet unrecorded, undisclosed, and coupled with regulatory consequences if ignored." The Solicitor General faltered. "That characterization is disputed, Your Honor." Denzel remained silent. His job was done. The Solicitor General tried again, referencing case law, but the justices, who had moments ago hung on Washington's every word, now wore expressions of quiet doubt. The government's argument sounded thin, almost hollow. Justice Thomas leaned back. Justice Kagan tapped her pen on the edge of her folder, considering. And Chief Justice Roberts, looking not at the Solicitor General, but at Denzel Washington, spoke once more. "This court has heard many compelling arguments," he said, "but what we've just heard is not only compelling, it's clarifying." He gave a slight smile, as if conceding a private battle. The Solicitor General lowered his head. His rebuttal was over before it began, and Denzel Washington, once doubted, now stood at the center of the most powerful room in the country, vindicated not by his name, but by the strength of his mind. 6 weeks after the argument, the Supreme Court released its decision in Williams v. United States, a landmark 6-3 ruling in favor of the petitioner, adopting nearly all of Denzel Washington's proposed constitutional framework. Justice Barrett authored the majority opinion. In a striking moment of judicial candor, her opening paragraph read, "This court is often guided by scholarly briefs from respected institutions. Rarely, however, does such clarity and historical insight come from a voice outside the legal establishment. Mr. Washington's proposed test is not only consistent with our precedent, it elevates it." She directly cited all 3 prongs of his test, embedding them as guiding criteria for evaluating government influence over speech in the digital age. She even quoted his oral argument verbatim. "Secret influence is inherently coercive." Chief Justice Roberts signed onto the opinion. Justices Kagan, Thomas, Sotomayor, and Gorsuch joined as well. The dissent, led by Alito, argued the court had overreached, but it was clear the majority believed the Constitution had been upheld more fully than ever before in this domain. The effect was immediate. Within days, agencies issued emergency guidance, halting back-channel communications with tech platforms. Senate committees launched investigations into executive messaging practices. Legal scholars flooded op-eds and podcasts, dissecting every word of the court's opinion. And Washington's brief. CNN's legal analyst declared on air, Denzel Washington didn't just hold his own. He reshaped First Amendment jurisprudence. Social media platforms lit up with headlines, Hollywood actor's legal mastery changes First Amendment landscape. Barrett praises Washington's extraordinary constitutional knowledge. Denzel Washington is now a legal legend. Reporters swarmed outside the court hoping for comment. When approached, Denzel simply smiled and said, "I didn't come to impress anyone. I came to defend the Constitution." And defend it he did, so thoroughly, even the court couldn't look away. Under the vaulted ceilings of Howard University's Law Auditorium, Denzel Washington stood before a sea of aspiring lawyers. The applause was thunderous, but he raised a hand gently to still it. "I'm not here because of who I am in film," he began, voice resonant. "I'm here because I did the work, quietly, carefully, and because I believed that truth, backed by preparation, could still be heard in the highest court of the land." Students leaned forward, visibly moved. "At night, between shoots, I studied constitutional law. Not to prove anything to anyone, but because justice, real justice, demands effort and humility." A week later, at Georgetown Law, Denzel sat beside Chief Justice John Roberts for a special forum on civic education. The tension of their courtroom encounter had long faded, replaced with respect. Roberts spoke first, surprising the audience. "I made an assumption," he said plainly, "and Mr. Washington made me confront it. His legal mind is remarkable, and more importantly, his argument reminded us all that brilliance isn't owned by any one institution. It's earned." The crowd stood to applaud. In classrooms and courtrooms across America, the message echoed. Preparation matters, humility matters, and when spoken with conviction, even the most unexpected voice can reshape the law. If this story inspired you and showed how preparation, conviction, and humility can overcome bias and reshape the world, don't forget to like this video, subscribe to our channel, and share your thoughts in the comments. We bring you powerful stories of unexpected brilliance and moments that challenge assumptions, stories the mainstream often overlooks. Hit the notification bell so you never miss a breakthrough like this one. Join us in celebrating voices that prove greatness can come from anywhere, and sometimes the most surprising messenger delivers the most unforgettable truth.